of Solicitor Advocates, and Paul Motion, Secretary of the Society. Gentlemen, can I thank you for your attendance this morning? I'm sorry you've been slightly delayed, but there's been some complex stuff this morning, as you have probably seen. So we'll now go straight to questions, and I'll put it to you, Dean. Is the current model for advocates, and indeed for solicitor advocates in Scotland, fit for purpose in our contemporary times?
I believe that it is. I noted that Professor Patterson referred to the proposed regulation of the faculty as skeletal. I would use the term concise. And I would also notice that the structure of the bill is, in my view, very important. And in that context, I would, if I might, just draw the committee's attention to Clause 86 of the bill, which, in my view, is really quite fundamental to the whole regulatory regime that is being proposed. And I mention it because in terms of Clause 86, it is, of course, provided that the regulatory authorities, and that includes the Lord President and the Court of Session, shall, of course, be subject to the regulatory objectives. Now, that is the umbrella under which the whole scheme then proceeds. And the regulatory objectives, of course, are found in Clause 1. And they have primacy not only in their numbering, but in their impact upon the bill as a whole. And if one appreciates that those regulatory objectives are central, they're the pillar around which the bill is constructed, then one can see that although there may not be lengthy provisions regarding some aspects of the Law Society's regulation or some aspects of the faculty's regulation, nevertheless, concise though they may be, they are effective and they're built around that central model. So if I can come back to the question, which I ought to, I consider that the present system works effectively, and that the proposal is going to be fit for purpose. And I would add only one thing, which is a point that Nigel Donn raised earlier this morning. In the context of the regulation of the faculty, who are principally involved in advocacy before the Supreme Court, an immediate form of regulation is an effective form of regulation, and that is the court exercising its right to regulate the behaviour of those who appear before it.
Mr. Marshall.
Thank you, Mr. Chairman. As the committee will be aware, there is already ongoing at the moment a review instigated by the Cabinet Secretary for Justice into rights of audience. The Society of Solicitor Advocates is actively participating in that review, and to a large extent we feel it would be discourteous to preempt the findings of the review. The principles on which we believe rights of audience must be exercised we have set out in the paper which we've handed in to you this morning. These are the principles which apply to all lawyers, which are internationally accepted throughout the European Union. These are the principles of conduct which apply as much to solicitors as they do to advocates, because they're to be found in the standards of conduct of the Law Society and the Guide for Professional Conduct of Advocates of the Faculty of Advocates. That's the fundamental basis on which we believe rights of audience must be exercised. As far as the bill is concerned, therefore, the main impact for solicitor advocates would be in the context of solicitor advocates who were a part of or were employed by a licensed legal service provider.
And you're quite happy just to leave it at that at the moment. I know there may be some inhibition until we get the interim report here in January. So you're quite content to leave it at that at the moment, Mr. Marshall?
Yes, if I may, Mr. Chairman.
Yes, I can understand the sensitivities. Stuart Maxwell.
Thank you, Convener. Can I just carry on a little bit in this area of questioning? I know you've mentioned in your written submission some of these points, but I'd like to discuss them here in front of the committee. But how effective do you believe is the court as the ultimate regulator of advocates? How effective is it in its operation?
If I don't know if Tom wants to respond immediately or whether I can respond to that. In my view, it is a very effective regulator at two levels. One, ultimately the court does approve all regulations of the faculty, and indeed may veto the regulations of the faculty, both as to admission and with regard to conduct. So that's an overarching regulatory role. But there's a more fundamental form of regulation, a more immediate form of regulation, which is connected to that, and that is that when an advocate appears in front of the court, he knows that the judge before whom he appears has the right to regulate his conduct and to ensure that he behaves properly, professionally, and in the interest of his client and no other interest. And that judge may, in the course of a hearing, although it's exceptional, intervene and point out that he is not happy with the conduct of an advocate or the manner in which representation is being carried on. So there are two levels to the regulation. I believe they're effective. I would notice that they have operated for about 300 years. Now, that's not to say that that's in favour of them, but they have operated, they have evolved, they have been effective, and in my view, one has to look beyond the provision, the express provision of regulation, that is the upper level, and bear in mind that secondary level of regulation, which is also very effective.
In practice, of course, that really is, what you're talking about is what happens during a hearing, the court's involvement there. But what about the wider aspect just of regulation of the faculty, or rather of advocates rather than the faculty? The court obviously, as you say, infrequently during a hearing would intervene to make the kind of statement that you've suggested, although it can do, obviously. But could you maybe explain to us how the advocates are regulated in their day-to-day work as opposed to just within the court?
Well, indeed. The regulations as to conduct of advocates are, if you like, initially promulgated and then submitted to the Lord President of the Court of Session. What actually follows in practice is then a series of meetings between the court and the faculty with regard to any proposed change in the regulations. And it is necessary for the faculty to make a case, if you like, as to why there should be some change in its own regulation. And only if that case is accepted by the court, by the Lord President, will the change in the regulation be accepted.
Would you not accept that there is a perception among some people, certainly, and some members of the public, that that's a bit of a cosy relationship?
That is sometimes suggested. I would point out that, first of all, one has to have regard not just to consumer interest, but to the public interest in the administration of justice. If you want to maintain a strong, independent Scottish legal system, you do actually require a strong, independent Scottish legal profession. Now, you're not necessarily going to weaken that by saying we can go to outside regulatory bodies, and I'm not suggesting that. But we have at the moment an effective system of regulation that has maintained a strong, independent legal profession and, in turn, a strong, independent Scottish legal system. And I would just notice that there are three things that distinguish Scotland between 1707 and the introduction of this Parliament. And they were the church, education and the law. And we did manage to maintain all three for 300 years.
I have no argument about the